Sexual Offences Against Children Act 2017 was introduced to address the seriousness of sexual offences committed against children in Malaysia. The main objective of this act is to provide for better protection for children against sexual offences and to safeguard the interests and well-being of children. Nevertheless, it is important for everyone to recognize and be aware of what the Act emphasizes. It will be presented in this video about the ingredients of the Sexual Offences Against Children Act 2017 in Malaysia in comparison with other countries. The Sexual Offences Act 2003 governs the law towards sexual offences in the UK. The Act has numerous wide-range provisions within it, including rape, assault by penetration, and many more. However, in the light of sexual offences against children, this Act was reformed to offer a stronger protection in preventing and protecting children from harm by amending the age from under 16 to under 18. Nonetheless, the main focus from this Act shall be on child sexual offences, which can be found under Part 1, Sections 9 to 15. Besides that, the Act also includes offences involving the abuse of position of trust towards a child under Sections 16 to 24, familial child sex offences Sections 25 to 29, indecent photographs of children Sections 45 to 46, child prostitution and pornography Sections 47 to 56, and trafficking Sections 57 to 60. Moving on, the highlighted issue to be compared here would be the law of sexual grooming offences in Malaysia and UK. In the process of grooming, the perpetrator will gradually create comfortable conditions with the child in allowing him to sexually abuse the child. Sexual abuse of children is always carefully planned. The perpetrators are regularly using internet chat rooms pretending to be someone as young as their victims, which is 16 and below, in order to lure them. In 2001, a 33-year-old man named Patrick Green pretended to be 15 years old, made contact in a teenage internet chat room for over 2 months of sending emails and texts with a 12-year-old girl. The girl was groomed and induced from the relationship to meet Green offline after Green convinced her that he loves her. As a result, the girl was then sexually assaulted by Green. At the time, there were no laws to charge the wrongful conduct even though the perpetrator was arrested. To cover the gap in the law, Section 15 was implemented in the Sexual Offences Act 2003. The offence under this section shall be complete either when, following the earlier communications, when the adult meets or travels to meet the child with intention to commit a relevant offence against the child. Recently, in 2017, Section 15A was introduced by the Serious Crime Act 2015 to supplement the offence under Section 15. Section 15A signifies the offences of sexual communication with a child, thus giving power to the courts to jail anyone who inflicted in sending inappropriate sexual communication of any form to a child. Similarly, there were no specific laws in Malaysia to address grooming of a child on the internet for purposes of sexual exploitation. There were arguments raised on whether Section 377E of the Malaysian Penal Code could be applied, but it was deemed difficult. Nevertheless, with recent amendments, it has been noted that the provisions regarding child grooming under the Sexual Offences Against Children Act is implemented, yet separated in its own part, which is Part 3. And Part 3 consists of 3 provisions, Sections 11 to 13. Without any doubt, the content of the provisions are similar to English law, including the relevant offences that may arise. However, the Malaysian Act has a stronger gist on child grooming as the provisions are clearly expressed with supplementary illustrations. In contrary, the provisions of English law seems to often contradict without its explanatory notes.
First of all, we may contrast the definition of child pornography. In Malaysia, as deriving from the Philippines Anti-Child Pornography Act 2009, child pornography is defined in Section 4 Sub A of the SOACA 2017 conduct. The meaning of sexually explicit conduct is set out in subsection 4b, which includes sexual intercourse, bestiality, masturbation, sadistic or masochistic sexual abuse, sexual exhibition of private parts, or the use of any object or instrument for lewd acts. In India, on the other hand, it has been expressed in the 2012 Act that the implementation of the Act is intended to avoid the exploitative use of children in pornographic performances and materials. As such, Section 13 of the 2012 Act has prohibited the use of child for pornographic purposes material. As such, to compare these two definitions, the protection offered under the 2017 Act is in fact wider in scope, as it does not just include a child engaged in a sexual activity, but someone appearing to be or portraying a child as well. Meaning, a 21-year-old who impersonates a child engaged in a sexual activity would be caught under this definition. It should also be noted that animations or drawings which appear to be realistic depictions of minors or person appearing to be a minor engaged in a sexual activity would fall under this definition as well. As for the 2012 Act, the acts of a child involving in pornography is unfortunately provided in a vague and too general way. For example, there is no defining provision as to what amount to an indecent or obscene representation of a child. Also, the 2012 Act does not expressly specify the representation in the form of audio. However, it has covered the use of child pornographic material in media such as program or advertisement. It has also added a proviso of a real or simulated sexual acts with or without penetration, in which these aforesaid provisions are not covered in the 2017 Act in Malaysia. Apart from the difference in definition, it is also worth making comparison of the punishment in connection with the child pornography in these two countries. For this, Malaysian law has laid down different punishments for different acts regarding child pornography, such as accessing, selling, exchanging, publishing, making, producing, directing the making or production of child porn, as well as using or causing someone to use a child in making, producing, directing the making or production of child porn. This is again wider in its scope of protection as opposed to the law in India, whereby the scope is listed in the explanation for Section 13. By and large, the highest punishment for making, producing, directing the making or production of child porn in Malaysia is 30 years of imprisonment and 6 strokes of whipping, while the lowest being 5 years of imprisonment or fine of 10,000 ringgit or both for accessing child porn. Nonetheless, the punishment may increase according to the nature of offense. In contrast, India has laid down the punishment for different categories of offenders. These includes those who directly involved in the child pornography by committing penetrative sexual assault or sexual assault in which they will be sentenced to maximum 8 years of imprisonment. Police officer who directly involved in child pornography by committing penetrative sexual assault or sexual assault will be sentenced to maximum 10 years of imprisonment. Those who are not directly involved but has used a child or children for pornographic purposes will be sentenced to a maximum of 5 or 7 years of imprisonment. Storing pornographic material for commercial purpose sentenced to maximum 3 years of imprisonment. All of these categories of offender will be liable for fine except the amount is not specified in the 2012 Act. It is obvious that the punishment in India is deemed less severe as distinguished from Malaysia, as the maximum sentence is shorter and there is no whipping for commission of offence, even though India has had different sentencing provisions for offence committed by police officer. After all, it is undoubtedly right to conclude that the 2017 Act is tremendously up to date as compared to the law in India in protecting the use of child in pornography. Unfortunately, some loopholes can still be found in the 2017 Act. This can be seen, for example, in Section 19, where it makes it an application to the community to report a child sexual offence or even an intention to commit offence to the nearest police station, whereby failure in doing so will make them liable for a fine of 5,000 ringgit. This provision is not deemed effective, as the question may arise as to how may someone find out one's intention to commit the offence. The law is also not clear as to when should someone report? Is it reasonably believed that the offense is going to be committed or has been committed, or the actual belief of the commission of the offense? Does that mean that a friend of the same age of the child is also liable for failing to report too? If the answer is positive, who is liable to pay for the fine? As such, some have suggested an amendment to the law to clarify on these regards. However, after all, the 2017 Act still remains as a good law in Malaysia.
Statistics from the Royal Malaysian Police PDRM shows that 22,234 cases of child sexual abuse have been recorded from 2010 to 2017, with an average of 3,176 cases a year. The number represents four categories of sexual abuse, namely rape with 13,272 cases. Wind News in 1999 reports that in Mumbai, 60% of rape victims are between the age of 3 to 16, with 50% below the age of 10. Unfortunately, these numbers represents only the most serious cases. 53% of children in India face some form of child sexual abuse from statistics in the year of 2018. However, it is believed that the incident is far greater than what has been reported to the authorities. Most never get reported to the police in the first place. Here, I would like to further compare the sexual offence such as rape in India and Malaysia. Firstly, the comparison on the punishment. Section 375G states that it is an offence to have sexually intercourse with a girl who is below 16 with or without her consent. Those who are convicted of rape can be sentenced to not less than 10 years to a maximum of 30 years and also whipping as stipulated under Section 376 of the same Act. One rape case involving a girl below 16 years old in Jamaluddin bin Hashim and public prosecutor in 1999, the accused was released. This is due to the technical difficulty in proving that the girl is 16 years old or below during the incident. In India, cabinets approved an amendment to the law protecting children from sexual offence that will set the minimum penalty for the gang rape of a child under 12 years old to life imprisonment or death. It also doubled to 20 years the minimum punishment for the rape of child under 16 years old. Thus, the weightage of punishment given in India is better in ordinancy in Malaysia. Secondly, on the comparison, who are the people who cause the rape? In Malaysia, majority of those who abuse children sexually are fathers, stepfathers or relatives, whereby in India, children who report having been sexually assaulted in 6% and the case where the abuser was in a relationship of trust with the children is 50% also. Home is the place where the children is the safest, but nowadays the scenarios has changed. In Ismail bin Rashid and public prosecutor in 1999, the appellant appealed for a lighter sentence. The appellant was found guilty for raping his two daughters and was sentenced to 14 years imprisonment and 3 strokes of rotan in first sentence and 15 years of imprisonment and 6 strokes of rotan in the second sentence. Lastly, on the comparison on why child rape cases are not reported. Coming up to the courts due to the fear the children does not complain about the incident. Such matters as secretly dumped inside the walls of the house to protect the reputation of the family. Despite over 20,000 reports of child sexual abuse cases, the Children Registry database has only recorded of 107 official cases. One way to stop child rape would be teaching your child body boundaries. Tell your children matter of fact that no one should touch their private parts and that no one should ask them to touch somebody else's private part. Thank you.
Mandatory reporting is a term used to describe the legislative requirement for a selected group of people to report suspected cases of child abuse and neglect to government authorities. Mandatory reporting is provided for under Section 19 of the Sexual Offences Act against children. Malaysia is one of the few countries which have implemented this action of mandatory reporting for offences against children. The main reason for the implementation of this section was to help prevent sexual offences towards children and to ensure they take the initiative to protect all children from sexual offences. With the implementation of this particular section, it now imposes a duty on the community to report any incidences or situations in which they may believe that an offence is being carried out towards the children. Under the Child Act 2001, Section 27 to Section 29 requires medical doctors, family members and child care providers to report a child who is physically or emotionally injured as a result of being ill-treated, neglected, abandoned or exposed, or who is sexually abused to the social welfare officers or police. There has been much debate in whether or not mandatory reporting is good in helping to reduce sexual offences towards children. The first criticism relating to the Malaysian section is where the person is required to inform the police about the commission of an offence. This may seem too general. It is therefore important for the law to be clear and specific before imposing such a legal duty upon lay citizens who may not be able to comprehend the law as well as others who have a legal background. In South Africa, mandatory reporting is much more easier to comprehend, where the duty is imposed on someone who has knowledge that a sexual offence has been committed against a child. Section 54 of the Sexual Offences and Related Matters Act provides for mandatory reporting for any suspicion or reasonable belief of the sexual abuse of the child, and provides that the reporting is done in good faith. The person reporting cannot be held liable in criminal or civil proceedings. The Act also compels all of its citizens to make the report of an offence. Another lack regarding mandatory reporting under the Malaysian law is that the law does not make it mandatory for teachers to report any sexual offences towards children. There has been some debate as to whether the legislative body should make amendments to the law to include teachers in being one of the professionals who have a legal duty to report. Reporting of sexual abuse is voluntary by teachers. Seeing as teachers are very close to children, it would make more sense to make their obligation to report mandatory. In India, mandatory reporting is provided for under Section 19 of the Protection of Children from Sexual Offences Act 2012. The difference of mandatory reporting in India is that the country's laws impose an obligation on every person, including teachers as well. However, when every citizen becomes a mandated reporter, it may lead to lodging of false complaints, and the question arises whether the penalty for false reporting will help prevent this. However, there are a number of studies which show that mandatory reporting of child abuse can reduce the cases of sexual abuse against children, especially when the perpetrators can be brought to justice. Countries such as UK and New Zealand have chosen not to implement mandatory reporting laws to avoid the over-reporting of innocent cases, as to ensure there would not be an adverse impact to the interests of the victims. Although there may be criticisms to mandatory reporting whereby the system is overburdened, inefficient and ineffective, which has in relation deterred family members from seeking help, mandatory reporting, which activates the state mechanism, can also sometimes be intrusive, insensitive, uncomfortable, embarrassing, expensive or even humiliating to all parties involved. The state's involvement is crucial and vital and is expected to play a constructive and supportive role, but this may fail when the review and monitoring mechanisms fail or are inadequate.
The courtroom may seem like a scary place to a minor, even more so if the child is a victim or witness to a crime committed by their own family members and is expected to testify by giving evidence as a witness. This rule is governed by the Sexual Offences Against Children Act 2017 under the Capacity and Evidence of Child Witness under Part 6. What is a minor? In Malaysia, under Section 2 of the Evidence of Child Witness Act 2007 defines the term child witness as a witness under the age of 16 who is called to give evidence, and it does not include the accused. A child witness suffering from disability such as physical, intellectual or sensory impairment may give evidence in other manner which is not described in the Act, and this is different from Singapore. The age of majority applicable in Singapore is 21 years old as provided by their common law. However, there are different definitions of a child stated in various legislation for specific purpose. The Evidence Act provides that all persons shall be competent to testify. It does not lay down an age restriction on children giving testimony, and the test is therefore whether they understand the question put to them and are they able to give a rational answer.
What is the law that governs witness and evidence in Malaysia and Singapore?
In Malaysia, it is governed by two main statutes. Firstly, the Evidence Act 1950, and secondly, the Evidence of Child Witness Act 2007, whereas in Singapore, it is governed by the Evidence Act 1997. One of the privileges of Malaysian law under the Evidence Child Witness Act is that it permits a special and secured setting for a child when testifying against the accused, such as setting up a special screen for the purpose of obstructing his view from the accused. The use of a video recording or tape recording as a mode of giving evidence, and the use of a live link evidence to enable the child to give evidence from a separate location or outside the courtroom, the use of the intermediary and others. In Singapore, the Convention on the Rights of Child Act under Article 39 says that even if a report is not made, the law allows the police to initiate the investigations if there is a reason to suspect injustices involving young and vulnerable victims. Investigations do not require the victim to lodge a report. Thus, when dealing with a young witness, the rule in Singapore is that a child who gives evidence, whether sworn or unsworn, must be corroborated, and this is the same as Malaysia. A child giving evidence does not include the accused. This provision excludes the privileges afforded to the child witness from being afforded to the child accused. A child and accused are in equal needs of the privileges as much as the child witnesses, since their liberty and future are at stake. According to Muhammad Alias from Justice for All article, Malaysia should seriously consider the abolishment of the corroboration warning. Mandatory corroboration should also be removed. It has been strictly defined, which makes conviction almost impossible in cases for minor, as this normally occurs in private where corroboration is almost none in existence. The case of PP and Muhammad Terang clearly illustrates this problem. The accused in this case was charged for the offence of outraging the modesty of 3 children aged 10 to 12 years old. The problem in this case was that 3 children gave unsworn evidence. The consequence of the corroboration rule was that they could not corroborate each other, as all 3 witnesses gave unsworn evidence. Therefore, the evicted and the accused was acquitted on 2 of those charges. Article by Aminuddin Mustafa laid down some amendments of the Evidence of Children Amendment to Section 133A of the Evidence Act 1950 on following matters. Firstly, to abolish the requirement of subjecting children to competency tests before they are entitled to give evidence, and to abolish the requirement of corroboration of unsworn evidence of children. In Australia, children under 12 should be able to give unsworn evidence if they are able to give an intelligible account of events which they have observed or experienced, and this is different from Malaysia. Judges should not be able to issue a warning to the jury to the effect that the witness is a child and is therefore less reliable than an adult witness. Recommendations for abolition have been accepted in some jurisdictions. For example, in New South Wales in 1985, the requirements of a corroboration in the case of the unsworn evidence of children and of a mandatory warning in all cases of a sworn evidence of children were abolished by the Australian Law Reform Commissions. In UK, in cases where a child witness is not competent to provide evidence, the parent or another adult who is aware of the child's statement may be permitted to provide that information by way of hearsay to the court. For example, in the case of R against Khan 1990, the mother of a 3.5-year-old child was not present when the child was sexually assaulted by her doctor during an examination. However, immediately after the examination, the child made a statement of what happened to the mother. From this case, the court did consider hearsay's evidence as an exception for the minor. As we can see, the Sexual Offences Against Children Act 2017 does not provide adequate and specific provisions on matters relating to rights of minor to give evidence in criminal proceedings.
Although the Sexual Offences Against Children Act has its downfalls, the Act serves its purpose by safeguarding and protecting the children in certain aspects as provided for above. Although some changes should be put into place to better protect the children of our future from such horrendous incidences, but for the time being, it does help in reducing sexual abuse towards children in some aspects. Maybe the legislative body should further study other developed countries and amend the Act to somewhat resemble their success in protecting children from sexual offences.